Hey, Steve Gosney in the chat. And Steve is quite correct. If you're watching this on YouTube or Rumble, please do whatever the equivalent of thumbs up is. Subscribe. Hit the subscribe button. Where are we with subscribers on Law Self-Defense? 48.8 thousand. Come on, folks. Let's hit 50. Why not? For 50, if we hit 50, I'll do a no-tie show just for all of you.
Do it! Just do it!
Rumble, do the same. Please, if you're on those platforms, leave a comment, even if it's just your city and state. And by the way, if you're a Law Self-Defense member, either a standard member or a platinum member, and you happen to be watching on YouTube or Rumble, leave a comment with your membership status to let other people know that you're out there. And maybe they should consider becoming a member as well. All right, folks, I remind all of you that if you carry a gun so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law so you're hard to convict. Until next time, I remain Attorney Andrew Branca for Law Self-Defense. Stay safe.
You got hit. I'm sorry I hit you like this, but I did not punch you. I did not fucking deck you. I fucking was hitting you. I don't know what the motion of my actual hand was, but you're fine. I did not hurt you. I did not punch you. I was hitting you.
How are you? Sorry.
You are such
Reverse
a
the genders and imagine how this would be going down.
Physical fights?
Yep.
I did start a physical
Yeah,
fight.
you did, so I had
Because-
to fuck out of there.
Yes, you did. So you did the right thing, the big thing. You know what? You are admirable.
Take a minute to really think about what you just heard there. Quote, I'm sorry that I didn't hit you across the face in a proper slap, but I was hitting you. I was not punching you. Babe, you're not punched. Imagine that was Mr. Depp saying that to Miss Heard.
I would drive that home over and over again.
Yep.
Which they can do for a mere 99 cents right now at lawofselfdefense.com/trial and get all their use of force questions answered for free, as opposed to having to pay $5 minimum super chats or Rumble rants. Another thing that I keep seeing people bring into discussion is, but Andrew, we all know that these subway systems are rife with violence. Everybody knows that. Surely that will play a role in Daniel Penny's defense. I mean, just in the last few days, I came across this, for example. BART is the Bay Area rapid transit system in the San Francisco area. He's slashing passengers with a cleaver. This is May 10th. It reads, breaking, a rough commute today, as an eyewitness tells us a seemingly deranged man with a butcher cleaver slashed a fellow BART rider today, triggering a car-to-car exodus. You think in San Francisco, where it's hard to get or impossible to get a concealed carry permit, probably illegal even if you had one to carry on public transit, you think people may be compelled to flee like crazy from a man wielding a cleaver? You think he had the cleaver under his coat before he decided to take it out and start wielding it? You think any homeless person, deranged, drug addicted, is likely to have a deadly weapon on their person if only because they live on the streets? I think those are all reasonable inferences. Here's another one. This is from New York. Just recently, within the last couple days. Fox News, New York City. Man who intervened in fight aboard New York City subway train is slashed in the face. The unknown suspect is at large. I guess this must be the suspect. You think Neely was aware of these kinds of stories? He lived in New York. You think any New Yorker who rides the subway is unaware of these kinds of stories? You think they're unaware of the risks they're incurring if they decide to restrain one of these people? You think that might be a reason that Daniel Penny took Neely's back, put him in a restraint, that other passengers helped control Neely's wrists so he couldn't readily access a weapon? But do you think any of this is going to be admissible at Penny's trial?
I doubt it.
Probably not, folks. Probably none of these stories that Penny may well have been aware of are going to be admissible at Penny's trial. Why is that? Well, it might be admissible if Penny can prove that he possessed knowledge of these events at the time he put Neely in a restraint hold. But if he can't prove that, all these stories are not going to be admissible, almost certainly, because they won't be relevant to a legal question in the case. Because the legal question in the case is going to be, did Daniel Penny reasonably perceive an imminent threat of harm, unlawful harm, from Jordan Neely?
The subway snugglers, I call him.
Yeah. So the
Daniel Penny.
Daniel Penny. Okay, yeah, I
Yes.
recognized the Daniel Penny name. I never watched that video.
I mean, he's got the guy like his arm is around him underneath his neck, and the guy's like moving around. It's not like he's not getting choked out by like fucking Jen's pulver or anything.
Right.
And then some other dude throws his arm, like has an arm lock on him. Like, people are holding this guy down, and you know, Jordan Neely gets out of the train. He's like one of these bums that rides the subways and is all over the place in New York City.
Yeah,
You don't get to go there. So like, 10 years ago, he dressed as Michael Jackson. But in the meantime, there's been videos of him just like shitting in the subway.
There's a Reddit thread from like 10 years ago about people talking about him, how dangerous he was. This was 10 years ago.
Oh, yeah, no. Well, he's a schizophrenic guy.
Yep.
So anyways, he gets on the train and is like, takes off his sweater. Like, he throws his sweater down. He's like, I ain't afraid to go back to jail. I ain't afraid to die. And people made it sound like, oh, he was begging for food. No, he was like, I want food. I want this. I want that. And everybody on the train was like, everybody in the subway car was like, this is getting a little fucking out of hand.
Right.
And then at some point, you know, our hero, the snuggler, comes up behind him and snuggles him.
Yeah.
Apparently snuggled a little too much, but that happens sometimes, you know. When you love hard, and you snuggle too much. But
because the legal question in the case is going to be, did Daniel Penny reasonably perceive an imminent threat of harm, unlawful harm, from Jordan Neely? That's the question. So it's from his subjective state of mind. By the way, if you don't know that's the legal question, you might consider picking up a copy of our 5 elements of self-defense law cheat sheet that goes over the 5 elements that are the building blocks of any claim of self-defense: innocence, imminence, proportionality, avoidance, and reasonableness. This cheat sheet lists those 5 elements, provides a brief description of each. It's 100% free, folks. We don't charge a penny for this. It's just a PDF download. You can get it at lawofselfdefense.com/elements. If you don't know these 5 elements, you have no idea how to evaluate a use of force claim or a defense of others claim. So I would urge you to download this at lawofselfdefense.com/elements. Now, if Daniel Penny knew of these other subway events at the time he put Neely in a restraint and can prove it, well, then it could be relevant evidence, because it could go to his state of mind, right? I was just supposing that every New York City subway rider would know this kind of stuff. But can they prove it? Because if you can't prove you knew it, well, then there's no evidence that you knew it at the time you used force. And if there's no evidence in a legal setting, it didn't happen. And it doesn't matter whether you actually knew it. It matters whether you can prove that you knew it. And if you can prove that you knew it, you can say, hey, here's the proof that I knew it. That makes it admissible because it goes to your subjective state of mind. I took Neely's back because I didn't want to get stabbed by him if he accessed a box cutter or a cleaver or whatever. Because I know that happens on the subway. And I can prove I know that, knew it at the time, because whatever, here's evidence. I keep a journal. I save the news reports. Whatever the case might be, some evidence. It doesn't need to be much, but it needs to be more than zero evidence.